So today we're going to have 4 panelists, essentially. I'm going to be sort of a moderator slash panelist, but I'm in the public finance group slash basically in the public finance group. Adam Gordon will also be in the public finance group. We've got Christopher Mason in our litigation group and Rob Coughlin in our corporate trust group within our global financial practice. So we're going to be covering LIBOR transition from a legal perspective. We're not going to be looking at the financial relationships between Sulfur and LIBOR, and we're not going to be looking at tax issues related to it. We're going to be looking at it from the standpoint of legal documentation. If you're a transactional person that's working on documents, we're going to look at it from the standpoint of, are you a borrower, are you a lender, are you a swap counterparty, and how that's going to work together. We're going to look at it from a trustee perspective, and we're going to look at it from a litigation perspective. So those are really the things we're going to be covering. So that's the gist of our presentation. Susan, if you can go to the introduction slide. And so the way that the presentation is going to go is Adam is going to cover the first column on the left there, the documentation discussion. So we're going to be talking about the impact of COVID-19 on the transition, trends that we're currently seeing in the documentation, recent guidance from ARC, and an overview of the ARC legislative proposal. Then Rob is going to look at this from a trustee perspective. So we're going to look at existing transactions, new transactions, the most concerning language in the documents that affect the transactions. And then Rob will go a little bit more into that proposed legislation that Adam will give you the overview on and how it could be helpful from a trustee perspective. And then Chris Mason will be our last presenter. He's going to pick up the litigation discussion. And there we're going to go into the reasons for litigation, the types or forms of litigation, examples of litigation that could ensue, and then what preparation you can do now for litigation. And then we'll come back and just sort of pick up takeaways from a documentation standpoint in addition to a litigation standpoint. And then we're going to open it up to questions at that point. So we'll be monitoring the questions that come in, and we'll try to answer as many as we can. So with that, I'm going to start it off by introducing Adam Gordon to talk to you about the documentation discussion from the borrower, lender, and swap counterparty perspective.
Thanks, Barry. I appreciate you having me on the panel. Can you hear me okay?
Yeah, we can hear you, Adam.
Great. So the first thing I want to talk about is the impact of COVID-19 on the transition. I think a lot of people are wondering, how it is going to impact the transition. And I think you can break it down a few ways. From a regulatory perspective, there's really no impact. According to regulators, the transition is not going to be delayed because of the pandemic. In early April, the Financial Stability Board came out and they said they were still on schedule for the 2021 phase out, and this has been consistent with European regulators. And so from the perspective of market participants, certainly there's been an impact. As expected, the pandemic triggered a change in priorities, and LIBOR and the transition was understandably put on the back burner for the moment as people had more pressing issues to deal with. So, I think that's certainly one way it's being delayed, but we still have the 2021 phase out date. The other interesting point I wanted to bring up is the effect of the pandemic on the legislation that's been floated around. We've been hoping for a legislative fix for this, or wondering if there could be. And, we know at least for what the ARC is proposing, and we'll touch on this a little later in the presentation, but we know that that's not going to happen in the near future because the legislation session in New York has ended. So it's going to have to be in January. So I think those are a few ways that the impact has affected the transition, but we're still on schedule for 2021.
Yeah, I think to add to that, we really are seeing a tightened time frame, because what's happened is some of the time deadlines that had been in place for 2020 have been pushed off to the end of 2020 or to early 2021. But the ultimate deadline of when LIBOR will no longer be in place still is 12/31/2021. So it means that, there's still going to be some new LIBOR contracts and things like that that continue during the course of this year. So there'll be a lot more contracts to amend, modify, et cetera, as we get into next year. So with that, just to, before Adam gets into more on the milestones and best practices from ARC, just to note what ARC is. The Alternative Reference Rates Committee, the Board of Governors of the Federal Reserve and the Federal Reserve Bank of New York put this committee together back in 2014. And the committee's been working all the way, since 2014 to come up with an alternative rate for LIBOR and other IBORs and a system to then implement that rate. And so we're now a little over a year into where ARC has published guidelines on fallback language to put into contracts. And Adam's going to go into the different types of fallback language, but they're guidelines to keep in mind. They're not regulatory guidance that people must adhere to, but they've been very useful as far as giving people insight as to how to maybe amend contracts in a way that can work for both the borrower and the lender, and then maybe also with the swap counterparty, so that we have a sort of a way to move forward and then hopefully come up with final language in 2021 that will be sort of hardwired to whatever this backup rate's going to be, and it looks like it's going to be Sulfur. Yeah. LIBOR is, ARC is made up of a diverse group, buy-side people, sell-side, end users, trade associations, intermediary market participants, and bank regulators and financial sector regulators. So we do have input on ARC sort of across the board. So it's, from that standpoint, it is trying to take everybody's interest in mind as it comes down with its recommendations. And with that, I'm going to move it back to Adam to talk about the milestones and best practices.
Sure. So you mentioned ARC has put out a lot in the past year, and there's really no shortage of material. So I'm not going to go into the detail specifically of all the proposed fallback languages and approaches. They really are product specific, but essentially sort of across the board, you have trigger events or transition events where LIBOR is no longer published or will not be provided, or that it's no longer representative as a benchmark. So when those transition or trigger events happen, there's ARC has proposed a few types of fallback language that parties should incorporate into the documents. The first approach, probably the most widely used approach, is the amendment approach, where parties will work together to provide a benchmark replacement with a consent of both parties. It could be Sulfur, but it doesn't necessarily have to be. And ARC is pushing very heavily now for their hardwired approach, where if one of those transition events happens, we go right into Sulfur. We follow the Sulfur waterfall that they have recommended and the spread adjustment. So in addition to the hardwired approach, there's also what they call the hedged loan approach, and that's applicable to bilateral contracts where there is a swap involved. And that is the way that's going to work. It's going to be somewhat dependent on the ISDA protocol, and Barry's going to talk about that in a second. But that's sort of the general sort of the view of ARC, what they put out in the past year. And just to comment on what we've been seeing in our practice, we're definitely seeing a focus of the issue by all parties, lenders, borrowers, and trustees. They're really paying attention to it. I think last year it was more of the wait and see approach. We'll see what people are going to be doing by this time. Now we're still seeing the wait and see approach, but the documents are starting to follow more ARC-inspired fallback language, notably the amendment approach. And I think lenders are still generally reluctant to take the hardwired approach because, as we all know, there's a lot of questions about Sulfur and will it be an adequate successor. So that's sort of what we've been seeing. And with respect to the ARC's best practices, Susan, if you can go to the next slide. Oh, we're there. So on May 27th, the ARC published some milestones and goals, and I think they're pretty straightforward. Sorry, Susan, if you could just go back one. But just to recap, I think they're helpful, fairly straightforward. That the fallback language should be included in new cash products. Third-party technology operation vendors should really do what they need to do to get their systems up to speed so they can handle Sulfur. And use of new Libor should stop. And the ARC actually provided a matrix which is product specific, to show exactly a recommended timeline. And finally, the ARC is really pushing, understandably, communication amongst parties. If there's one party has discretion over the successor, that they should notify the counterparty. So straightforward, but again, helpful things to think about. And then Susan, now go to the next slide. So this is the matrix that ARC delivered. It's on the ARC website, and I think it's helpful just to sort of break down what they're looking at by product and the specific deadlines that they suggest. Now, they're suggesting that the hardwired approach be incorporated, by now at this point, and we're still not seeing that. So clearly, this is a helpful guidepost, but it's not really indicative of what we're seeing. But again, the ARC is trying to make clear that people need to be paying attention to this. From an internal perspective, there's a lot to be done in assessing Libor exposure and doing that due diligence. And I think the third sort of point that ARC is pushing, which makes a lot of sense, is really just sort of be aware of market trends and, follow closely ARC guidance, and because there's not a lot of time left. So, really, especially in the midst of the pandemic, it's time to focus on that. So I've talked a little bit about ARC and their approach, but also important is what's going on with ISDA. And we know that ISDA expects to publish amendments to the 2006 definitions to incorporate fallbacks, and we think they're going to be similar to the ARCs. And Barry is going to give us a little more context on that.
Make sure. Thanks, Adam. Susan, can you move us to the next slide? Okay, so I think the key we want to point out here is to coordinate from many perspectives. But if you're a municipality, let's say, the only reason you're involved with a derivative is because you're trying to hedge risk. And typically, let's say it's interest rate risk if it's an interest rate derivative. And so you need to coordinate your rate on your hedge versus your rate on your loan or your bond. And where we can get into trouble is if it's not coordinated well, we could end up with a disconnect on either the rate itself, that's the fallback rate, or on what the trigger is to cause that rate to come into play. So what ARC has done is, in their fallback language, we have both trigger events and we have actual, recommended language if we use the hardwired approach. So the ISDA protocol and the ISDA amendments, they should get published at the same time. At this point, the hope is that's going to be in July, so next month. Now, and then it'll be effective 4 months after that, but people will start, I'm sure, putting it into their documents. Having said that, the timing of July, with the effective date in November, we've had a couple of previous dates where the hope was that the protocol was going to be published, and for one reason or another, it was not. So that's the timing right now. If that gets delayed, we'll just have to monitor that, but it'll be important when it comes out. And the thinking is, on the protocol, certainly right now, that first of all, with trigger events, that they're going to match up with the trigger events that ARC is showing now. And that is, we talk about pre-cessation and post-cessation triggers, but the big change there that's happened in the last few months is the pre-cessation trigger, so that if a regulator releases a statement essentially that Libor is no longer representative of the market, that will be a trigger point that Libor will be then being phased out of the document that you're in. And that should apply both if on the loan side, if you've used ARC language, and then on the swap side, if you use the protocol. Separately, the protocol is going to have in it the specific, hardwired language. So until we see it, we don't know all the specifics, but we expect it's going to be some sort of a compound Sulfur type rate plus a spread, depending on the term of the swap and other factors. And so if you've got a loan that you're looking at, and the loan has, let's say, ARC language or no language at all, or something even different than that, as Rob's going to go into, you really have to consider with your lender what you're going to do on the loan side before you adopt the protocol on the swap side. The way the protocol is going to work for existing deals is it's going to be the option of both parties to adhere to it and use it to amend the document. So you're going to want to sort of communicate on the lending side as well before you do that, to see if you can make sure that this is going to all work well together. Additionally, within banks, from a standpoint of coordinating, we're going to want to make sure that the lending side and the derivative side of the bank are talking if you're using the same bank for both the loan and the swap. So coordination is important, from the borrower side, but also from the lender swap counterparty side. And then again, on timing for documentation changes, the hope is, again, that the protocol comes out in July. If that happens, then you'll start seeing it, as well as the amendments to 2006 is the definition. So we'll start seeing that put into documents pretty much right after that on the derivative side. So they'll have to be looked at closer if you're doing new loans, to try to pick up language, if you can, more of a hardwired approach to match up with your swaps. With that, Adam's going to give us an overview of the legislative proposal that ARC put forth to the New York State Legislature earlier this year.
Thanks, Barry. So on March 6th this year, ARC proposed legislation, and to really address a couple common scenarios that we've been seeing. And I mentioned earlier in the presentation that a legislative fix was on the table. So this certainly not without controversy. So those scenarios that I just mentioned, you've got contractual provisions where the fallback is LIBOR, or you've got contracts that are silent on the end of LIBOR. So just very quickly, here's what the legislation would accomplish if enacted. If there's an existing fallback language that references a LIBOR-based rate, the legislation's recommended benchmark will override it, which could be Sulfur. For contracts that have no fallback language, the recommended benchmark replacement would become the fallback. So that would remedy the second scenario. The legislation will also eliminate existing fallback language that requires polling for LIBOR. And the other interesting thing to mention is that if parties select the recommended benchmark replacement, there's a litigation safe harbor there. And certainly that's to encourage people to use this ARC approach. So that's the very sort of high-level overview of the legislation. There's a lot of controversy to it, and I think both Chris and Rob are going to touch on it. But that really sort of covers what we want, that I want, the items in my part of the panel. So thanks, Barry. I'm going to turn it over to Rob now.
Thanks. So let's advance the slide one. There we go. So let me give you an idea of the look of the world from the perspective of the trustee. So indentured trustees are going to have in front of them portfolios of different sizes, and they're going to be looking at their book of business in terms of let's say 2018 or thereabouts transactions, and then current transactions going on. In terms of the first, which I'll refer to sometimes as legacy transactions, they're essentially all over the place in the sense that depending on what the products are in the portfolio, whether they're corporates or munis or structured finance or securitization, they'll tend to have a variety of different terms. Some of them will allow a party to simply pick a replacement rate. Some will require a party to pick a replacement rate. In some cases, that party may be the trustee, or it may be another party. In some cases, that choice is supposed to be the selection of a comparable rate without really defining what that is. And in other cases, it's supposed to be based on comparable information or some other articulation of a standard that is maybe articulated, but usually not well defined. Others will be more clear in saying that the fallback will be something like prime or federal funds or some other specified rate. Other transactions will vary in terms of when those triggers, when the transition to those replacement rates is supposed to happen. And then a large segment of many transactions, and much of what I'm going to talk about in a few minutes, contain provisions that are referred to as polling or sometimes dial rate. And those are provisions that said, essentially, if the rate's not available on Reuters-Thomson, the trustee or the calculation agent is supposed to make telephone calls to some designated number of London banks, usually 4, but sometimes it's 4 or at least 4. And the selection of those banks, by the way, may be designated or may be up to the choice of the calculation agent or up to the calculation agent's choice after consultation with another party. So again, there's lots of variation there. And the goal of that is to come up with 2 quotes, at least. From that, an average would be determined. But if you can't get 2 quotes, you go to some number of New York banks and you ask them for quotes. Again, trying to come up with an average. Failing that, those terms usually contain another provision that I will refer to as last LIBOR. And that's a provision that says if the rate's not available on Reuters and you haven't been able to come up with a rate or determine a rate from polling, then the rate for that interest period is going to be whatever the LIBOR rate was for the last time you were able to determine it. That's why it's referred to as last LIBOR. Obviously, the impact of that is that if LIBOR has gone away permanently, then that poses the prospect of having a variable rate instrument go to become a fixed rate instrument. To compound matters, many trustees, certainly those in the structured finance area, but including some others, will also find they have LIBOR issues, not only with the securities for which they act as trustee, but also in underlying collateral. If they hold collateral comprised of loans or bonds or other cash flow instruments that are indexed on LIBOR, then there's going to be some impact on LIBOR transaction at that level as well. As you can see, it's a complicated picture. Now, starting roughly in 2018, the market began to come to grips with LIBOR transition. And so in those transactions, you will see an increasingly robust embrace of the ARC terms. For products that simply designate another party as having authority to designate the replacement, that may not have been so necessary, but another transaction, certainly those that have the polling provisions, there has been a recognition, essentially, that polling is not likely to work. And so there's been, as they say, increasingly robust adoption of the ARC provisions. But those are also all over the place in the sense that some adopt hardwired provisions, some adopt an amendment approach, and many adopt variations of each of those, or even combinations of each of those. In some cases, now you will see, or since 2018, you will see sort of a flow from one alternative to another, again, providing for the trustee a wide variety of what's in their portfolio. This evolution has continued into the present in the sense that in terms of current transactions, there is a great, I will say, embrace of the ARC provisions and a great embrace of recognition that LIBOR is going away and that the drafting of current documents has to address that. But again, let me make a few observations about what we're seeing. With respect to the adoption of ARC terms, there is a wide variety in how they are being adopted and how they're being customized, depending on the preferences of the transaction parties and drafting counsel. So if someone says a particular transaction has ARC terms, that doesn't tell you much. You really have to look at the details. The other observation is, curiously, polling provisions continue to be included in documents, even though there is widespread recognition for a variety of reasons, that those terms are just not going to work. And the terms that include polling provisions are most likely going to be matched with less Libor provisions, meaning if you can't get a rate from polling, you're going to go to whatever the last available Libor rate was, and that's essentially going to fix the rate at that rate. But yet those terms continue to be used. Happily, they are usually matched with some version of ARC provisions, either hardwired or amendment, as a final fallback. But they're still in there. The other curiosity is that Libor obviously continues to be used at all, but there has not been, at least in my experience, widespread adoption of one of the proposed alternative rates yet. And I guess the last comment that I'll make about current transactions is with respect to the dynamics you're going to see from trustees. You're going to see a few things. Trustees are, for obvious reasons, very focused on what the Libor fallback terms are in their particular documents. They very much favor incorporation of ARC terms. They are neutral on whether it's ARC or something else. If the parties wish to agree to some other fallback, the trustees are going to be agreeable to that. Trustees are not driving the dynamics of the economics, certainly. As long as the terms are clear and as long as they achieve a replacement, that's really the goal of trustees. You will often find trustees asking that polling provisions not be included for obvious reasons, but they still continue to be. And as I said, the main theme from trustees is they want certainty, they want clarity, and they want provisions that are clearly going to achieve some replacement rate. In that regard, trustees don't want to be involved in making judgments about those things, and be aware that judgment can come in a variety of ways. It can come in not just in terms of selecting a replacement, but it can come in terms of what the trigger to the benchmark replacement should be. At what point is Libor no longer representative or unavailable? See terms sometimes referring to industry recognized standards or comparable rates and the like. Trustees don't want to be making those determinations. Or certainly determining calculation methodologies for compounding or for spread adjustments and the like. They will perform the calculations, but they need clarity and certainty as to what the methodology is. One comment on the ARC provisions: that continues to be an evolving field. There are still many uncertainties with regard to ARC. We've talked about the fact the term Sulfur is not yet available. That's at the top of the hardwired waterfall, but there's some commentary as to what's going to be necessary in order for a term Sulfur to be published and whether that really will be achieved. Methodology for compound Sulfur is not yet ascertained. There continue to be announcements about spread adjustment methodologies that needs to be clarified and worked out. And ARC obviously is coming out with announcements all the time, and likely will come out with more between now and the actual transition. So the point here is that you need to see the particulars of your particular transaction, and you're going to see a wide variety out in the various products, depending on whether they're corporates or munis or securitization or structured finance or what. Let me emphasize for a moment the dialer rate and last Libor provisions, because they are widespread and they are commonly viewed to be problematic in the sense of, imagine leaving aside the question of whether quotes will even be available. And there has been some discussion in the market as to whether there may be some public announcements by reference banks that they simply won't be making quotes, so please don't call us, that sort of thing. The notion of tens of thousands, potentially, of trustees, calculation agents, paying agents, making calls at 11 o'clock London time each morning or weekly or monthly to a handful of London banks to come up with quotes is just operationally challenging, to say the least. And the general recognition is that the reality there is that that's not going to work. And even if dialer rate or polling were to work, question whether getting 2 quotes from an arbitrarily selected reference bank and taking an average of that is anywhere reflective of what Libor is currently, as people talk about the differences between current Libor and some of the other alternatives out there. So, facing this, what are trustees doing? Well, as you can imagine, they are going through a fairly difficult process of due diligence, going through their portfolio, figuring out what's in there, what do the transition provisions say, what do the fallback provisions say, what will each require by way of administration or operation, and in particular, identifying those that simply have administrative or operational challenges as opposed to those that have more substantive challenge. And by substantive challenge, I generally mean anything that by its terms is not obviously going to effectuate a smooth move to a replacement rate. So provisions that have dial rate and last Libor, unless parties are comfortable with the last Libor provision, meaning it's going to go to a fixed rate absent any other solution, has a challenge to it. Likewise, there are many transactions out there, and I didn't mention this in my earlier summary, that present the greatest challenge, and that is they have no fallback provisions at all. So those are obviously situations that are going to have to be addressed one way or another. In the course of that due diligence process, you are likely to see over the next 18 months trustees undertaking some sort of outreach or communication with other transaction parties, and they may decide to do that for a variety of reasons. They're not necessarily required to do it, but they may decide that it's necessary or will be useful either to bring certain matters to their attention, to facilitate communications if some parties want to initiate amendments, or to facilitate communications as to whether there are other ways to address whatever the situation may be in terms of administering or carrying out transition. But certainly where there are no fallback terms or terms that are not going to be clearly effective, you are likely to see some communications, or you may see some communications from trustees to other transaction parties, hoping to work together with the other transaction parties to avoid some of the other alternatives that we're going to talk about in a minute. The principal alternative in situations where you face something that's problematic is obviously amendment. One of the goals of the ARC provisions, or the ARC recommended provisions, obviously, is to facilitate a process of amendment by providing terms in the newer transactions that allow certain amendments to be adopted without investor consent or with some reduced percentage of majority, percentage of investor consent, depending on what the selected replacement is, to facilitate that process. The reason for that is prior to ARC, in most transactions, what you're going to find, and certainly those that are TIA qualified, are provisions that simply say, when facing amendments, if you're going to amend a term as material as interest rate, you need 100% of consent of the investors affected. So you're going to need consensus between 100% of the note holders and the issuers over what the replacement rate should be. And then in structured deals, where you may have a zero-sum cash flow, even the change of a variable rate note may be determined to affect the other notes, because you have cash flow in which different note classes are going to be affected depending on how the cash flow to other note classes is allocated. So the short answer is there may be some transactions where amendment is possible. There are likely to be many where it's simply not going to be an option.
Hey, Rob, just to
Yeah.
sorry to interrupt for a minute there.
Yeah.
If I think so that we make sure we cover the litigation stuff.
Yeah.
Let's see if we can get your slide wrapped up in the next minute or so, and then we'll keep going.
Yeah. Let me jump to that. So, a couple of quick things. Trustees will be the other thing that's happening is over the next 18 months is trustees will be fielding some inquiries. Trustees welcome inquiries, but please don't look to the trustee for answers. They would like to work with other parties, but they don't necessarily have answers to a variety of these things. And then the last point is, so what happens if you have transactions that have dial rate or polling or last LIBOR or some other, or absent any fallback provisions, or have something else that doesn't work? Well, the last tool is judicial remedy. And by judicial remedy, I mean from the perspective of the trustee, one of the procedures, whether it's interpleader or declaratory judgment or trust instruction procedure, that looks for guidance to a court, that brings a matter before a court and asks for guidance, gives notice to interested parties so they can come in and be heard, to get guidance. And when I talk about it, I'm talking about it either in terms of something investors might initiate or other transaction parties, or the trustee might initiate, or a consensus may be reached among a group to come forward and initiate litigation. But the point of all that being to avoid, to come to a consensus, to find a resolution to, or get guidance from the court as to what a resolution should be, how the situation might be resolved. Quick point about the New York legislation. If you remember what Adam said about what the legislation is focused on, it would directly address many of the issues that I described as being problematic, and therefore I think would be certainly welcomed by trustees. But let me turn over to Chris, because I think, as Barry said, he has perhaps the most important part of today's. Chris?
So, folks, thanks for joining our webinar today. And if you could move the slide, please, Susan. Thanks. So we've had COVID-19 for a while, and in the midst of this, people are finally starting to take litigation risk seriously. There's a publication called RiskNet Daily that some of you may get, and they had a headline the other day which just said, as replacement rate concerns become more pressing, firms fear LIBOR lawsuits and regulatory wrath. And I have to tell you, it's been COVID-19, the courts have been closed, and the litigation tiger is hungry. Litigators are ready to litigate. Susan, next slide. But I want you to, put aside regulatory wrath for a second, and let's just think about the kinds of litigation that are going to occur. You heard Rob talk about the perspective of somebody in a trustee's position. I just want to give you some ways to think about litigation that you might see. It's a little bit different. Just start with this. Some disputes just involve basically two people. They're bilateral, or maybe two or three people. One side of a transaction, another side of a transaction. Some disputes involve somebody stuck in the middle, like a collateral manager or a trustee. Some disputes involve a person trying to speak for a group. So you have a class of people who believe they were injured, but typically there's one or a couple of people who really want to push an issue, and the dispute's an aggregate type of dispute. And then there's the kind of dispute that definitely arises in transition issues like this, whenever there's disruption, which is some people will see litigation as an investment class. They will simply look around and try to find the best opportunities to litigate to make money for themselves, not because they're in an ongoing transaction that they've had a relationship in, but because that looks like a good investment. So 4 different ways of thinking about litigation. Next slide, please, Susan. So let me give you some examples. Bilaterally, obviously, a typical term loan, a bank and a borrower. There's 2 parties to that. There's going to be a rate in there. And if you've got a small number of people, you have a reasonable chance of coming to an agreement about what a replacement rate should be. And if you can't, there could be litigation, but the litigation typically offers some opportunities for resolution along the way. And if people have a long-term relationship, it may not be the world's worst dispute. It's just a judge trying to help people decide what to do. The second kind of example, where you've got somebody stuck in the middle, think of a CDO structure, right? You've got different classes of note holders. They probably have different views about what benefits them in terms of a replacement rate. If you're at the very bottom of a structure and a replacement rate looks like it's going to be more expensive, then you might object to it because it might cut off your ability to receive a return. And the trustee or collateral manager or person in the middle sort of throws up their hands because they don't know what to do. Different people have different views. And this is where, when Rob talks about things like trust instruction proceedings or interpleader, those are methods for helping resolve those kinds of disputes. And they can be very useful, and some of them can be used by the person in the middle. Some of them can be used by a party who has a particular position. But that's the man in the middle problem. Then you've got sort of the aggregate problem. So think about an RMBS structure. So you've got a borrower who's actually got a mortgage, and that person says, I don't like the new rate that was chosen by the servicer for this adjustable rate mortgage. I'm going to sue everybody under the sun. I want to represent a class. Or suppose it's a bond issuance and somebody looks at it and says, well, I think the way that's being used to select a rate isn't correct, and therefore I want to proceed. In these kinds of cases, there are really, really complex procedural issues. Sometimes people in these positions who want to sue can do so easily. Sometimes they can't. Rob mentioned something called TIA qualified, so Trust Indenture Act qualified transactions. The Trust Indenture Act has some provisions that restrict things, allow people to say that you can't just have a single note holder sue. But there's some exceptions to that. And you'll probably see some big fights over things like Section 316B of the Trust Indenture Act, which gives an absolute right to demand the payment of principal and interest. Where does that right begin and end? Courts really have struggled with that over the years. But these kind of collective actions will proceed. There will be some of them. And some of them will be not just because there's an interest among somebody who has a current relationship, but some of them will be because somebody's acquired an instrument because they think litigation is a valuable way to make money. And you'll see that with some hedge funds that may well take positions and be activist about particular issues. They'll find an arbitrage that can exist between what can be done in the structure and what cannot be done. Perhaps something like you're seeing a little bit in the CLO space right now. And that'll be an interesting thing to deal with. Right? Now, next slide, please, Susan. So you're saying to yourself, that's great. You've given me some categories. You've described a couple of things, a couple of examples, but what in the world can I do about all this? Well, it's the same thing that the deal lawyers are going to tell you. They're going to say, know what your holdings are. If you are a party that has LIBOR-denominated debt, or in fact, transactions that aren't debt that are LIBOR-denominated, know what it is you have. And know what it is that you have across multiple departments. Don't let the folks on the swap side of your business decide that they agree with Barry and they like the way that swap stuff works if the people on your Treasury department who are sitting on some other instruments don't like that. Understand your holdings, right? Second, typically those of us who are in the sort of big money business oftentimes think of ourselves as more likely to be defendants than plaintiffs. But this is going to be a situation where you may end up being both at the same time in different transactions. Or you may, if you're somebody like a man in the middle, you may need to be a plaintiff. You may need to start an action to be able to solve your problem. Which means, another point, make sure you think of active management. Don't just sit back and wait for somebody to sue you to fix your problem. Active management means the kinds of things that Rob was talking about. You may want to, and it's a decision that depends on this particular issue you've got, you may want to reach out to your counterparty on transactions and start the discussion. You may not want to wait for them to do that. You may want to have a deep dive into whether you can, in fact, amend your documents or whether you can't, and what the cost will be of doing that. If you find that you're in a position where you can't have a conversation and you can't get an amendment and no regulator is going to help you and you've got to think of litigation, I can tell you from having done this in other contexts that you can actually have discussions with your opponent. And I've done it with folks in some other structured finance contexts where you call up your adversary and say, We're going to have to figure out how to do this. Let's talk about the right form of litigation to solve this problem, right? So you're also going to want to think, if you get to the litigation point, where do I want to do it? Right? You have choices. And there are some venues that are notoriously bad. If you're a defendant facing some class action activity by a typical class action plaintiff's lawyer, there's some places that are very good for solving certain problems. From the trust instruction procedure side, for example, New York has a special provision, Article 77. Minnesota is well known for having a very good trust instruction procedure statute. And then there's some really complex, interesting issues if you've got folks who are not on shore. If you have to solve a problem where you've got to make sure you've got jurisdiction over people overseas, you have a lot of really hard problems and you have some limitations on what you can do. But there's actually a federal interpleader statute, which is the only federal statute that actually provides for worldwide jurisdiction if you use it in connection with something called the Lien Enforcement Act. It's very, very technical, but think about this when you're looking at your problems. Are they purely domestic? Who are the players? Do I have both sides of a problem? Do I have international folks? You need to really understand this. And I want you to watch for proposed legislation, even if it never passes. Right? So the New York proposed legislation that ARC put forward, you can go to their website and you'll see the language that they were going to propose to the New York State Legislature. It never got introduced, which is not hard to do, by the way. In New York, you can introduce a bill very easily. You can find somebody to do that for you, but it did not get introduced. One reason may be just that people were busy with COVID-19, but who knows? If you think that legislation, and if you look at it, you think it's valuable, you may want to contact folks on the political side of the equation and say, I think this would be valuable to people. I think it would be useful. But even if there's never any legislation, look at what it was, because it's a considered discussion, in effect, of what's reasonable. And when you're in litigation, a large part of what's going to happen here is whether when you choose a reference rate of some kind, whether that choice was reasonable. And by reasonable, we're going to think about not only the result, the outcome of it, but the process you use to get to it. So think of it a little bit like what you see in a shareholder derivative suit, where somebody says, did the board make a good business decision? When you make a business decision, you look at the procedure that you go through. You look and see whether you've identified good, high-quality, non-conflicted professionals to advise you. You look at whether you considered more than one option, and then you make a decision. If you do that kind of process work, it will help you in litigation in this context. And I cannot stress enough that there's going to be litigation. There just will be. When you listen to the beginning of this, where Adam was talking, I think you were probably thinking to yourself, wow, there's a lot of stuff going on. And then when you heard Rob talking about how even the stuff that's going on to make it all the same isn't making it the same. People are not adopting ARC language. They're changing it. And when you realize, when Rob tells you that we don't even have a good understanding yet of compound SOFR or term SOFR, and when you realize that when you're talking about comparison to Libor, you're maybe talking about SOFR plus some rate on top of that, there are a lot of choices that will be made. Anytime there's a choice to be made, somebody can disagree with it. So I look at this from a litigation perspective, and look, I've been doing it a long time. I don't think litigation is the world's best way to solve problems most of the days, but it's going to be necessary. So get yourself prepared. Take a look at what you've got, talk internally, talk to your outside counsel, and make sure that you are starting to think of a plan, okay? So I think we may have a little bit of time for questions. Barry, what do you think?
Yeah, thanks, Chris. Yeah, we have about 6 minutes. We're still experiencing some difficulties. I got knocked out and I'm back in, so that's good. Let's try to address some of the questions that came in. One of the questions was, is the protocol expected to be a hardwired approach? If so, will borrowers be requesting lenders to adopt the same approach on the loan side? I'm looking at this from a lender perspective. So it should be a hardwired approach. There should be an actual benchmark rate plus a spread that's in the protocol that would be the fallback rate. I think what we tried to address earlier is that it's very important to coordinate the two. So we do need the borrowers, before they adopt the protocol or agree to something on the derivative side, to be in contact with the lenders on the lending side. So if you're a lender and you're looking at it from your side, your point of view, if another part of the bank is the derivative side, the bank should be working together now to see if they can come together on what the trigger events, make sure that you guys agree on the trigger events and on the backup rate and on any kind of adjustments that are going to be made to the rates and those kind of things. If we have a lender and a counterparty that are different entities, it's even more complicated. The hope would be that as sort of an industry basis, if we get most counterparties wanting the protocol to be adopted, and that's what we've seen in the marketplace. Most of the dealers that we speak to are waiting for the protocol to come out so they can adopt it. So then on the lending side, the hope would be that the lenders would want to amend the documents in a way that matches up. So that's a key thing to think about. If you're a borrower, you definitely do want to be requesting lenders to do that. If you're a lender, you want to be thinking about who the counterparties are on those related swaps so that you can work together to try to get them matched up. Okay. There was a question on the interplay between compound Sulfur and the existence of state laws that impose restrictions or prohibitions on compound interest. I guess from a documentation standpoint, that's not something that we've looked at within public finance in particular. Chris, from a litigation standpoint, have you had any reason to look at that previously?
We haven't, except in the context of sometimes having challenges to something being improper because it exceeds a certain rate. And there's a dispute going on right now. There's a case that's come out of California with a referral to the New York Court of Appeals on something sort of like that in the litigation funding context. But I'll be honest with you, I haven't thought about it in the context of the switchover from Libor.
Yeah, Barry, I'll add one thing there. When the hardwired terms talk about compounded Sulfur, they're talking about, I believe, compounding to determine the rate, as opposed to, I suspect the state laws are talking about compounding the actual interest accrual. Those are two different things. I haven't looked at it either, but I suspect.
That's something we will likely look at that, and we can certainly at some point once we can get back to a broader group and certainly to the person that asked that question. There was a question about, do you have an option to print out these slides? We'll make sure that these slides are distributed after the webinar is completed, so don't worry about that. There's a question on why does Libor need to be eliminated in the first place? Basically, there's a without getting into too much, there was a lot of controversy on Libor. It wasn't, there's been litigation. It's almost like a polling type of situation, and it's been shown that it was not done in the most appropriate manner. So when you get down to it, there's just not enough out there where Libor is not based on actual transactions. So that we needed to come up with an approach that would give people much more confidence in the market that they've got rates that they can depend on, and those are legitimate rates. There's a question on how will the cost to lenders change under Sulfur versus Libor. Again, from the lender's point of view, you're going to have you're going to have a difference in the rate. It depends on the idea is that you're going to pick a Sulfur rate plus a spread that's very much equivalent to Libor. That would be the hope, so that there wouldn't be a big change. But there's certainly volatility between the two. We're not financial people to speak about volatility. That may be something we cover in a separate presentation. But again, the hope would be that when Sulfur is put in there, there's a spread attached to it that makes it very much equivalent to Libor. I don't see any others questions on where I'm reviewing right now. Does anybody else see anything?
So Barry, let me speak to one thing about the last comment you made, because there was a question we got from somebody earlier before we started that was asking a little bit about stuff in the consumer space and asking the question of what happens if one of the regulators passes regulation that's in effect says a rate is reasonable. Is that going to mean I'll have no litigation risk? Okay. So I just want to tell people the answer to that question is no, it doesn't mean you have no litigation risk. That's why people were looking at legislative solutions. And you can look particularly in connection with what the CFPB is doing in the Reg Z space, where they're going to have potential regulatory action where they're going to mention a rate, which will probably be Sulfur, as being a reasonable rate, and they're going to allow people to make transitions, and this is actually pretty important, make transitions away from Libor on a fixed date, even if Libor has not been declared to be unavailable. And right now their proposal is going to be March 15th of 2021. But the problem is that when you look at your transactions, what you're required to do to find something comparable, it probably won't be just to substitute Sulfur for Libor. It would probably be Sulfur plus something, as Barry mentioned. And if you're going to have to pick what the something is, then that's going to keep you at risk because you could pick wrong. The CFPB is going to want people to look at, replacement rates as being equivalent to Libor in the way that they move. So if you track them, they go up and down the same way Libor does. And they're going to probably want you to think about, is it reasonably equivalent in terms of the actual price? Because sure, a rate could go up and down like Libor, but it could be 5,000 basis points higher, and that wouldn't be reasonably equivalent. So as much as we'd like the regulators to solve our problems for us, it's not going to happen. You can reduce your risk by looking at safe harbors, reduce your risk by seeing what it is that other experts say, again, thinking about the process you go through to make sure you select the appropriate rate and implement it appropriately.
I think in terms of other takeaways, we talked about litigation takeaways, other takeaways, number one, everybody on the call should make sure that they have a good understanding of what their Libor exposure is. Where is it? And what are the fallbacks right now? How does it work? Do we have any of those scenarios that Rob went into? Where if you've got a derivative and that's all you have, let's say you've got polling, as Rob was talking about, so you don't really have a solution right now. But that protocol is likely to come out hopefully next month, and then we'll see a potential solution. But that's the first big thing. Make sure you understand what your exposure is. Second big thing again is coordination again on your swaps and your loans to make sure that before you agree to any change to either side of that document, you've talked to the lenders and the counterparties, if you're a borrower, to try to make sure that that's going to match up as best as it possibly can. And I think it's in the lender's interest to have it match up. Nobody wants to have a mismatch because then the whole point of the hedge is eliminated or harmed, and you're going to have basis risk and things you really don't want to have. So coordination, very important. Know your exposure. And keep in mind for new deals, question anybody that wants to do a new deal based on Libor right now. I mean, based on the guidelines, you can still do them, probably at least till the end of the year. But if anyone is promoting the idea of a new deal with Libor, they really need to have fallback language in there that you're going to be comfortable with if you're a borrower. And from a lender's point of view, similarly, you don't want to have more deals out there that you're going to have to amend in a tight time frame next year. So you want to have, if you feel the need that it needs to be Libor right now, then the fallback language is very important, at least to have an ARC type language that's workable on how to amend it going forward. That's sort of those I'd say are the key takeaways from the transaction side. Anybody else want to add anything, Adam or Rob?
I think you covered it well, Barry. I think, again, it's just looking through, preparing for the transition and really thinking ahead when we're doing new deals so we don't get into trouble.
Yeah, no, I would also echo everything that you said and being proactive and as Chris said, taking a close look at what you have and deciding whether it's going to work or not work is.
Okay, Chris, anything else on litigation?
Nobody wants to hear about litigation. Thanks.
Okay, well, thank you, everybody. We're a few minutes over, but we started a few minutes late. We had some technical difficulties, so I hope everybody enjoyed the presentation. We enjoyed providing it, and we'll try to get back to anyone that has any questions that we didn't get to. Thanks very much.